much, IPKey team. Good morning, everybody. It is my very pleasure to be here with you again this morning and discuss with you the protection of well-known marks and a measure to prevent bad faith registration. A heartfelt thank you again to the team for putting this series of seminars together. I think it's really important for ASEAN, for the region, for many countries in the region that are now, some are more advanced stage, others just starting examination of well-known mark. They are facing bad faith registration and they are looking into guidelines on how to address these specific challenges. First of all, as I started in my previous seminar, I think it's really important to look at terminology. We have, and we're going to see very soon in this webinar, an international infrastructure, and the international infrastructure, which is based on the Paris Convention and the TRIPS agreement, plus, of course, other treaties that facilitate registration of mark. But these international treaties talk about well-known marks. And this is also the title of our seminar. On the other side, other jurisdictions following the terminology that has been first used by the European Union, the very early trademark directive back, still, 1988, 1989, talks about marks which have a reputation. Then I'm also going to discuss the US system because it's also a very important system as a matter of reference. In that system, we talk about famous trademarks. These concepts are very similar, they overlap, but they are not the same. And that is really crucial to see from a territorial standpoint how the protection of these marks is going to be addressed in a variety of jurisdictions. So terminology matter from the legal standpoint of actual protection. First of all, of course, when we talk about well-known marks, we talk about marks that are well-known, that are notorious, that are famous, they have a reputation in the jurisdiction where these marks are either used or maybe not used, but known about by the population. And here again, we will need to very clearly distinguish whether the consuming public is a sector of the public or is the public at large. These are just some pictures with some example of marks that are certainly well known to the vast majority of our readers today, those of you who are online listening to this seminar. These are consumer goods, from cars to fast food, to coffee, to shoes. These are also well-known marks in the fashion industry, very well sought after in the region for sure, where people are very keen in purchasing luxury goods in the fashion industries. These are some of the very well-known marks for cars. Asia has certainly many famous marks for cars, and to a large extent, many Asian brands are coming up now. So when we think about why we want to protect well-known marks, it's not just because we want to protect foreign marks into Asian jurisdiction, but it's also because as Asia is growing, the economy is growing, products are more developed locally, several of these products become also famous, well-known abroad as well. And as a result, the protection of well-known marks become convenient and important for all marks across a variety of jurisdictions, not just necessarily foreign marks into Asia, but also Asian or specifically some of the ASEAN trademark. Think about Gojek for Indonesia, for example, how established the name is becoming the region, and possibly beyond the region as well. It's important for us to start this specific seminar by reminding why do we protect well-known marks. And initially, the rationale is we know that trademark convey three specific functions. Trademarks are protected because they have three, some might say four. I would condense the third and the fourth function in one, protected function. The first function of trademarks is to identify commercial origin. To identify Coca-Cola versus Dr. Pepper versus Pepsi-Cola versus Red Bull, when we have a series of products that might look the same because they are all in a can, if we don't have identifier to tell us what product is what, we can't obviously choose between competing different products. And so the identification of products as coming from a certain origin is the first commercial function of trademarks and also the first legally protected function. And this is why the traditional standard for trademark protection is protection against a likelihood of confusion. In addition, trademarks protect quality in the sense that trademark indicates to consumer that every mark, every product identified by a certain mark has consistent quality. And here again, the protection is justified from a standard against likelihood of confusion. But in addition, trademark protect also the so-called advertising function and investment function, so the goodwill function of trademarks. And here the protection is against what we call dilution, the whittling away of the distinctiveness of the mark. Here you see the famous picture of a Benelux case that to a large extent is the origin of this protection, Clarins versus Clarins, for spirits versus dishwashing liquid. And even though there is no consumer confusion, there is clearly a likelihood of association that can end up into a tarnishment of the reputation of the first mark and eventually also an erosion of the mark distinctiveness. Paris Convention Article 6 bis is the first provision internationally that protects well-known marks. I am going to spend a minute going through the text of this provision because I think it's really important. The country of the Union, so all members of the Paris Convention, undertake ex officio or upon request, most countries do that upon request, to refuse or to cancel the registration or to prohibit the use of a mark with, and very carefully please, look at the specifics, which constitute a reproduction, imitation, or a translation which is liable to create confusion of a mark considered by the competent authority of the country of registration or use to be well known in that country. It is a period of at least 5 years from the date of registration, according to which there is that window that the owner of the mark that is well known can ask for the cancellation of the mark. In addition, if the mark in the second country is used, not registered, the country of the Union may provide a period for the prohibition of the mark to be requested, but that period can be longer than 5 years. Moreover, no time limit shall be fixed if the provision, if those marks have been register or use in bad faith. This is why this seminar wants to combine the concept of the protection of well-known mark with the measure to prevent registration in bad faith. And the reason is because most of the time, the bad faith registration concern well-known marks that are not yet registered in the country, but are well-known already in the country for a commercial activity that is entertained by people outside the country. This is today very much an issue because of the internet, and we can know about marks much faster. Their fame can grow much faster, yet perhaps those marks are not registered as fast in all countries where they become well known. And so, and I'm taking a term from the domain name world, we start to see trademark squatters, people who run to register marks that are famous or well known abroad, but not yet registered in another country, to try to take advantage of that mark reputation in the country where they try to register. That is almost invariably done in bad faith, and is something that the international framework has long ago provided for prohibiting. Now, Paris Convention Article 6 bis still linked the cancellation of well-known marks to similar goods, still only goods, and based on the traditional function of trademarks, these goods that are identical or similar, so say colas for colas, or soft drinks, cars, jewelry, as long as there is a likelihood of confusion. However, that interpretation has been expanded later with the TRIPS agreement. The Paris Convention does not specify specific measure for the protection of well-known marks nationally, but certainly the member of the Paris Convention would be not complying with the norms of the Paris Convention if they don't provide for the recognition of well-known marks. The TRIPS agreement expands the reach of Article 6 bis. Article 16, 2 and 3 provide, first of all, that the provision of Article 6 bis is extended to services in addition to goods. In addition, the TRIPS agreement clarifies that in determining whether a mark is well known, the competent authority should take into account the knowledge of the mark in the relevant sector of the public, including as a result of the promotion of the mark, not necessarily of the actual sales of products. Plus, Article 16.3 provides that Article 6 bis is extended to cover products, goods or services that are non-similar to those in respect to which a mark has been registered, as long as the use would indicate a connection between those goods or services and the owner of the registered trademark, and provide that the interests of the owner are likely to be damaged by such use. It is clear that this provision was heavily influenced by the already in force at the time trademark directive in the European Union and the protection for marks which have a reputation. At the same time, we should not forget that the United States at the state level had a wide protection for trademark dilution. Still at the state level at the time, the protection, the federal, the country-wide protection anti-dilution in the United States was first enacted after the TRIPS agreement was adopted. So under the TRIPS agreement, one of the very emblematic case was the McDonald versus Joe Burgers in South Africa. This is a traditional case, but this case is interesting because McDonald had registration in South Africa, never used the mark. Joe Burger opened his own McDonald restaurant, applied for trademark registration, and petitioned for the cancellation of the McDonald registration. McDonald contested the application, requested that Joe Burgers would be enjoined from using the mark, and the court found in favor of McDonald, saying the marks were well known. The marks by Joe Burger would create deception and confusion among South African consumers. Now, note that the products were the same. This case was decided in 1996. Under the old South African law, trademarks were only protected against passing off, and so we did have to have goodwill in the actual country. And it's still questionable whether a mark that is not in use can have goodwill in a jurisdiction. Courts are deciding without consistencies on this specific issue. But under the new South African law, the Paris Convention and the TRIPS agreement had to be implemented, and so the protection of well-known marks has to be implemented. And accordingly, the court found that Joe Burgers was clearly a registration in violation of the well-known TRIPS and Paris Convention provisions. Because of the definition of well-known marks and how to assess whether a mark is well-known or not was a bit under question, again, because back to the terminology, we have the word well-known, we will see in a minute the word famous in the United States, mark which have a reputation in Europe, and we don't really have in the Paris Convention nor in the TRIPS agreement a guide in terms of factors to weigh at the moment of assessment of what is a well-known marks. In 1999, the World Intellectual Property Organization issued a joint recommendation defining a variety of criteria to assess what well-known marks are. And Article 2 of this joint recommendation, that is soft law, however, it has been introduced in many of the member states' laws. The factor to consider whether a mark is well known are the degree of knowledge or recognition of the mark in, again, the relevant sector of the public, the duration, extent, and geographical area of the use of the mark, the duration, extent, and geographical area of the promotion of the mark, the duration and geographical area of the registration and or application of the mark, the record of successful enforcement, the value associated with the mark. So these multi-factor tests are useful and are a guidance for the courts, for the examiners to identify whether a mark is well known. In addition, the guideline says clearly that this is a non-exhaustive list. The above factors are not precondition for reaching of the determination. Rather, the determination in each case will depend upon the particular circumstances of that case. In some cases, all the factors may be relevant. In other cases, just some of the factors may be relevant. In other cases, none of the factors may be relevant. And courts and offices might look at additional factors as well. The relevant sector of the public, that's again is a very important question in the determination, is the actual or potential consumers, person involved in the channel of distribution, the various business circles. And so again, this is a very, very relevant assessment to make. What is a well-known mark? What is the relevant sector of the public? Now, in addition, Article 3, and I call attention to Article 3.2 in particular, bad faith may be considered as one of the factors among others in assessing competing interests in applying the provision of the joint recommendation. And and a mark shall be deemed to be in conflict with a well-known mark, whether that mark or an essential part thereof is a reproduction, imitation, or translation liable to create confusion of a well-known mark. And here you see Article 4 repeats at large Article 6 bis of the Paris Convention. And so in this case, we clearly have, the example of McDonald's versus the Joe Burger. Reproduction, imitation, likely to create confusion for similar goods and services. But Article 4 then extends and so encapsulate Article 16.3 of the TRIPS agreement. Irrespective of the goods and services, a mark shall be deemed in conflict when these are reproduction, imitation, translation, transliteration. Remember the Jordan case in China, for example. If there is a connection with the goods and services and the owner of the mark, that would likely damage his interest in a way that can impair or dilute in an unfair manner the distinctive character of the mark, or would take unfair advantage of the distinctive character of the well-known mark. I want to show you a couple of cases now in Malaysia, and this was a case decided under passing off. On the other side, despite these specific provision, the Court of Appeal reversed High Court ruling dismissing McDonald's claim for passing off because there was no misrepresentation for a local business to use the McCurry, and was not an identical mark, was not for identical, was still for the food services, but the court didn't find confusion, didn't find association either, and so didn't found that this mark was nor in bad faith, nor was had to be canceled or used. But in Singapore, McDonald's successfully opposed the application by Future Enterprises for McChocolate, McTea, and McNoodle. And here you see very similar sounding marks, even though the MAC is still different than MC from McDonald's, but clearly there is an eagle that remember the American flag. But the court found that McDonald's could continue, so that the Future Enterprise could not block McDonald's from using McCoffee. So to repeat, McDonald's opposed these various registration. Eventually, even though they're very similar to McDonald's, the Court of Appeal found that Future Enterprise could use the word Mac for noodles, tea, and so on, but not for McCoffee, because McDonald's actually has a McCafe. Now, moving to the United States, I think it's really interesting to see how we have seen the international framework under the Paris Convention. Under United States law, what is protected under the Trademark Dilution Act, which has been implemented into the Trademark Act, the Landman Act, what is protected is famous mark. For those who are interested, I'm happy to give more information about the United States, but offline, because between 1994 till 2006, there's been variation in the law. But as of today, America protects well-known marks under the anti-dilution doctrine, which has been incorporated into Landman Act Section 43C. On the other side, if a mark is not registered in the United States, the Article 6 bis protection for well-known marks, we will see in a minute, and that's very similar also under the European directive, don't get protected beyond the likelihood of confusion. Here I show you, here is a page, is a screenshot of a page of the United States Patent and Trademark Office explaining specifically the limitation and how the United States recognized the well-known marks doctrine. But under Section 43C, the owner of a famous mark that is distinctive shall be entitled to an injunction against somebody else who uses at any time a mark that is similar to the mark that has become famous when this mark is likely to cause dilution by blurring or dilution by tarnishment of the famous mark, regardless of the presence or absence of actual or likely confusion, competition, or actual economic injury. For the purpose of defining what is a famous mark and what is the public, I think here is very important to see as different than the Paris Convention and TRIPS and the well-known marks guideline. Famous is a higher threshold. To be famous, a mark has to be widely recognized by the general consuming public of the United States. The factors to consider that is the duration and extent and geographical reach of the advertisement, the amount, volume, and geographical extent of sales, the extent of actual recognition. Then the law defined the difference between dilution by blurring and dilution by tarnishment. Blurring is the association between two marks in which the distinctiveness of the famous mark can be whittled away, can be affected by the use of the second mark, based again on a variety of factors, while tarnishment is a negative association, an association that can harm the reputation of the famous mark. There have been cases related to, for example, Toys R Us and Guns R Us, or something related to adult entertainment, so more pornographic sites that were using the playing with word R Us, and that, of course, was tarnishing the reputation of the mark. Now, an interesting example, just recently, there are many, many examples, I just want to give you a couple. After the famous Disney Frozen mark was registered, and here you see just several of the registration, some of these mockbuster movie companies started to use the name Frozen Land for some of these products, and Disney filed a lawsuit, and immediately, Frozen Land has to stop using the mark. On the other side, for well-known marks that non-register in the United States, the USPTO uses just the likelihood of confusion test in deciding whether to protect a well-known mark or not. There is no separate analysis apart from the likelihood of confusion of deceptiveness. The USPTO will refuse the registration of a mark that conflicts with unregistered or unregistered well-known mark, but we need to have confusion if there is no registration. There have been several decisions by United States court deciding the doctrine of well-known marks, and still we don't have a unanimous approach across the United States. The Supreme Court has declined to take up, in the United States, we have many different federal circuit divided by region. So the Court of Appeal for the federal circuit are, there is a variety of them. And because being a common law jurisdiction, the law of each Court of Appeal apply in that specific district. But when two or more federal circuit decision conflict, then there should be a petition to the Supreme Court, to grant certiorari, and then the court should clarify the law, and then the unanimous application should go across the United States. We still don't have that. The United States has declined, the United States Supreme Court has declined at this stage to take a decision, to interpret the doctrine of well-known marks, by the Supreme Court to have a unanimous approach. So back in the 1990s, the Federal Circuit Court of Appeal found that even though an American business person had gone to Japan, seen some clothes in Japan, and then clearly copying the mark in the United States, the Japanese company didn't have any claim for standing, and just they apply pure territoriality. In 2004, the Ninth Circuit, in a case called Grupo Gigante, actually found that well-known foreign mark that was well-known in Mexico could actually have a standing and claim to cancel a national mark when a substantial percentage of consumer in the relevant American market is familiar with the foreign mark. So you see, here the decision was actually different, and the relevant market, rather than all the American market under the dilution doctrine of Section 43C, was adopted. In Pongini in 2007, on the other side, the Second Circuit, so the New York court, found that the Landman Act doesn't create any exception for famous mark if those have not been used and registered in the United States. But then in 2016, the Fourth Circuit found that the fact that Belmora, which is a national company, was using a mark for a medicine using the same name that Bayer had used for many, many decades in Mexico, was also deceptive and misleading, even though Bayer was not using that name in the United States, because many American consumers, particularly of Latino origin, knew that name. The Supreme Court denied certiorari, and so at this point you see we have a differentiated approach across the United States in this respect. One of the really emblematic cases in the United States is the Cohiba case. Cohiba is, of course, a well-known mark in Cuba, but there is another registration in the United States by Cohiba, not by a Cuban company. In the United States, all Cuban business is forbidden, not under trademark law, but under the embargo law. And General Cigar, which is an Haiti, Dominican Republic company that has, of course, subsidies and lots of American interest, has the registration in the United States. Cuba Tobacco filed a cancellation. There's been multiple litigation across the United States for this specific case with different results. At this point, Cuba Tobacco has been denied relief by the Second Circuit in 2010 based on the embargo law, not on trademark law. But under trademark law, this decision is absolutely wrong because it's a clear violation of the Paris Convention and the TRIPS agreement. And clearly, it's a violation of international obligation by the United States. There is the same issue with Havana Club, rum, and there's been even a decision against the United States by the WTO regarding Havana Club, yet nothing has changed at this point. And I think that's really wrong. The United States should comply with its obligation under international trademark law. And the Cohiba case, the Havana Club case, are clearly examples of violation of that. Bad faith in the United States is taken very seriously. There are several types of bad faith registration. Banking trademarks is bad faith in the United States because we have to have an intent to use when we register a mark, and we will not get a registration unless we file a statement of use. And of course, registering with intention of just using a mark a little bit, it's also a bad faith registration. And of course, trying to take advantage of somebody else's reputation is bad faith. In the United States, there is a statutory duty. Most jurisdictions have that, but in the United States, there is really an oath that the registrar, the applicant has to sign, and the lawyer representing the applicant has to sign. And so there is criminal prosecution of perjury, and there is possible sanction on the attorney, the agent representative. These are some examples of bad faith registration. And for example, as I mentioned earlier, the Balmora case was decided. This is not the exact same case, but it's exactly about the same marks. And Flanax, the fact that the American Balmora company used the name Flanax was found to be in bad faith. The fact that this individual filed for the mark L'Oréal Paris for aloe vera drinks was also found to be in bad faith. The other, and I think that's really might be a suggestion for offices across the region, in the United States, there is a very large requirement of transparency. And so all the papers filed with the USPTO are available online. All papers that are within opposition also are available online. All the files are public, and that can really create a trail of paperwork that can be seen by by the various possible opponents, but also by the public at large. Here you see, this was the example of the registration that had to be signed by then the individual who wanted to have, the L'Oréal case. And now moving to the European Union protects marks that have a reputation. That has been the case ever since the very first trademark directive, and the same definition has been continued throughout all the directives. It's also important to understand the origin of this provision. This provision came into the European law from the Benelux law. The Claron decision, that there was really the seminal decision for the protection of the reputation and the goodwill of a mark based on the likelihood of association rather than the likelihood of confusion, stems from the Benelux standard. I'm going to look at the European Trademark Regulation, the European Directive that has also been reformed with the trademark reform packages, has the same language. So a proprietor of a registered earlier mark can apply for opposition. The trademark apply for shall not be registered when it is identical with or similar to an earlier mark, irrespective of whether the goods and services are identical or similar, where the trademark has a reputation in the union, or in the case of an earlier national mark, the mark has a reputation in the member state concerned, and where the use without due cause of the mark applied for would take unfair advantage of or be detrimental to the distinctive character or the repute of the earlier trademark. Now, Article 9 of the regulation says, without prejudice of the right of the proprietor, the trademark shall be entitled to prevent all third party not having consent from using in the course of trade any sign which is identical with the mark, etc., etc. So Article 8.5, it's the provision that the examiners need to look at the moment of registration, while Article 9, it's the provision that grants the right to the trademark holder to prevent individuals using similar or identical marks also for non-similar goods and services beyond the likelihood of confusion. Under the European IP Office website, which is extremely well done, you have, and here's the screenshot, guidelines that tell you specifically all the grounds for opposition, and Part C, and specifically Section 5, has the guideline related to the application of Article 8.5 of the directive And so the guidelines and all the examples and the explanation that the examiner will follow. And I really strongly suggest all of you interested in this topic to carefully look at those guidelines, perhaps not just section 5, but the old guidelines. This is the 2020 updated version. You also have, you know, the previous one. There is lots of great examples and is very, very well detailed, and is certainly a very important resource, even just informally for examiners, for anybody interested, you know, trademark attorney, anybody interested in this area. Now, page 1052 of the guidelines says, well-known marks that are non-registered in the relevant territory, however, very similar to the United States situation, cannot be protected under Article 8.5 against the similar goods. They can only be protected against identical or similar goods if there is a likelihood of confusion. So that's important. One could even wonder, are the United States and Europe not in line with their TRIPS Article 16.3 obligations? Because under Article 16.3, as interpreted in line with Article 6 bis of the Paris Convention, there is a clear obligation to protect and expand Article 6 bis, which does not talk about necessarily registration, but just use for also non-similar goods and services beyond the likelihood of confusion. So a very interesting scholarly paper here could be written with some empirical studies whether most jurisdictions that do not implement extended protection under Article 6 bis as expanded according to 16.3 of the TRIPS agreement actually are not in full line with the international obligation. On the other side, page 1052 of the guideline also says that this is without prejudice that the well-known mark can be protected also under the similar goods and services, but not under Article 8.5, but under Article 8.4. That specifically discusses the Paris Convention protection. Where a well-known mark has been registered, then yes, of course, there is the protection of Article 8.5, but here the issue is when a well-known mark has not yet been registered and the owner of the well-known mark needs to act to oppose or to apply for the cancellation of a previous registration. Now, Article 8.1.2c says on opposition by the proprietor of an earlier trademark, the mark shall not be registered. Earlier mark means the mark which at the date of application, where appropriate, the priority claim in respect of the application are well known in member states in the sense of Article 6 bis of the Paris Convention. But here again, only within likelihood of confusion, similar goods and services. The overlap between the concept of well-knownness or reputation is highlighted in the guidelines as well. But in general, under the European Union law, the assessment for reputation is both a quantitative assessment and a qualitative assessment. The degree of knowledge of the earlier mark, quality, image, prestige, and what should be proved, the nature of the use, for how long the mark has been used, the place of use, and the extent of use. This is a slide that comes from a presentation by the European IP Office. These are the various means of evidence: company profile, market survey, ranking, recognition award, press articles, statements, sales turnover, invoices, advertisement, and so on and so forth. Factors: the relevant public must establish a link between the marks, and that we look at the similarity of the sign, the degree of reputation, the overlap of the public, the proximity of the market sectors. The type of harm are Very similar to what we explained before, rewriting, dilution by blurring, dilution by tarnishment. Rewriting and blurring in the United States are addressed under the same heading. In Europe, they are divided in two. They're very similar. Now, in the guidelines, you have several examples. I'm just going to give you some. Royal Shakespeare Company for theater production was able to block Royal Shakespeare registration for non-alcoholic and alcoholic drinks. And here the General Court found that the European trademark would benefit from the power of attraction, the reputation, and the prestige of the earlier trademark. Viagra and Viagra, I think, there is clearly, Viagra is probably one of the most famous trademarks in the world. And so here the General Court held that a mark would also serve to transmit other messages, and the risk of taking unfair advantage encompasses case of a manifest exploitation or parasitism of a mark. And so Viagra was registered for drinks, even if the drinks claim that the mark applied would be not produce the same benefit as the immensely well-known pharmaceuticals. That was certainly a factor important for consumers. Those of you who have ever been to Spain know that there is a chain of restaurants called Vips. On the other side, in this specific case, the court found that the mark Vips has a reputation for restaurant. However, it's not proven that it also enjoys any particular prestige. The term Vips is laudatory in itself. There is no explanation how the sales of a software product, because Vips was applied for a software product, would possibly benefit from the association with a fast food chain if the link was made. So you see, here is an example of a mark that was opposed but eventually was granted. Now, Camel brand for cigarettes and Camel brand for foodstuff, they're very similar. Even if you look at the design of the brand itself. And so the earlier mark used to arouse immediate association with the goods for which it's registered will no longer be capable of doing so. It followed that there is a clear probability of damage of the earlier mark advertising function as a vehicle for building up or retaining brand loyalty. These are screenshots from the guideline. I think, again, I really want to guide you to the guidelines because they are an excellent document prepared by the UIPO. I would say far better for these specific issues than, say, many other guidelines of IP offices. These are probably the golden standards of guideline. I strongly encourage everybody to read them because they are highly explanatory with a lot of very interesting examples. Kappa for sports clothing and Kappa for tobacco products was also found to be tarnishing, and so this specific marks was successfully opposed. Here, clearly Louis Vuitton, and then you see a very similar pattern for scientific, nautical, surveying, weighing, measuring, signaling, checking. Here again, tarnishment in association, were found. So that will be detrimental to the image of the mark, which opponent carefully fostered for decades. And, going to the bad faith registration in the EU consider bad faith as an absolute ground for invalidity of the mark. And how do we assess bad faith? These are some of the factors: identity of the marks, the knowledge of the use of an identical and confusing marks is not sufficient per se, but it's relevant. The circumstances under which the contested sign was created, the nature of the mark that is applied for, the degree of distinctiveness of the senior mark, and the fact that, for example, the marks that has been applied for has been already declared invalid in member states or in other countries based on bad faith. On the other side, these are factors that are unlikely to show bad faith. that we are trying to apply for a long list of goods and services, or that, you know, the mark enjoy reputation at the national level and so on. This is a case that is applied, you know, one of the most cited case for bad faith registration. So one of 3 partners of a company applied for the registration of this Café del Mar, and there was an invalidation based on the fact that the other 2 partners own Café del Mar, and so there was, you know, an attempt that very often is the case that you know, associates split, and then one tries to register the mark that they were all used together. And now, finally, I want to conclude looking at one of the jurisdictions in ASEAN, specifically Indonesia, and the 2016 law. I also want to thank again the colleagues at Universitas Indonesia for helping with the sources and the examples. I want to specifically thank Dr. Henny Marlina, because she has been very generous with her time in helping me finding several of these examples and pointing me to the sources of specifically also the translations of the current law. So the current trademark law in Indonesia has been revised quite recently. And you can see Article 21(1) states an application shall be rejected if the mark is similar in its essential part or its entirety with a well-known mark owned by another party for similar goods and services, or a well-known mark owned by another party for the similar goods and services will meet certain requirements. And from the explanation in the law to this provision, some criteria are provided to assess whether a mark is well known, and the knowledge of the public in the business area concerned, the reputation of the mark due to intensive and large-scale promotion, evidence of registration of the mark in several countries. In addition, the regulation that accompanied the new law, Article 18 defined the public as a consumer and public in general who has a connection with the production, promotion, distribution, or sale for the various goods. And then here again, you see there is a list of factors, very well detailed, non-exhaustive but relevant for the assessment of whether a mark is well known. So I would say again, pointing clearly at the law in Indonesia as a very mature, at this point, I would say a very well detailed and a good example for the region of a clearly defined law in line certainly with the international obligations. In addition, the commercial court can order an independent institution to conduct surveys with the purpose to establish whether a mark is well known. And the technical guideline for the substantive trademark examination of the Director General of Intellectual Property also are of use, even though these guidelines are now being revised. In addition, there is ASEAN guidelines for substantive examination that I think in the region could really be helpful for the various offices. In addition, Article 21(3) of the law has specific provision for bad faith. The application shall be rejected if it is, if an applicant is acting in bad faith. And the explanation to what bad faith is shall be an applicant who, in registering the mark, is reasonably suspected of having the intent to imitate, copy, and free ride on the mark of another party for the purpose of advancing his business interests and create unfair business competition, deceiving or misleading consumer. Plus, the guideline even have examples. And what is important here is seeing this is an example of an applicant not acting in good faith because it can be at least reasonably assessed that there is an element of deliberatedness in imitating the well-known mark. This has certainly been a problem in the region, not just in this region, but in many countries of this, what I'm calling again, trademark squatters running to try to register well-known foreign trademarks. And I think, you know, here the DGIP technical guidelines really look at an application shall be rejected based on bad faith if similar or copy of the entire you know, drawing created by other people for registered trademark for dissimilar goods and services, if there is a copy of the logo, if there is a copy of the way, you know, the mark, for example, a logo has been registered copyright or application. So these are also very important guidelines. These are a couple of examples. Giordani has been registering class 3, while Giordano was registering class 18 and 25. Those of you who are based in the region know Giordano is certainly quite well-known mark for clothing, and the owner of Giordano filed a cancellation against Giordani based on the fact that Giordano is well-known and registered in many countries, and previous court decision in Indonesia found that the mark was well-known. Giordani refused the claim, arguing that also Giordani was well-known, but couldn't bring more than 3 registration and no declaration of the fact that the mark is well-known. Initially, the commercial court refused claims, arguing the cancel, but then, and the main issue was the cancellation was filed after 5 years, but the Supreme Court reversed and canceled Giordani and found that Giordani was registered in bad faith. And so, again, back to the Article 6 bis, the time window of 5 years doesn't apply when there is a finding of bad faith. So I think, again, here we really see very important decision by the Supreme Court of Indonesia. Very similar in the IKEA versus IKEMA case. IKEA is, of course, a worldwide famous trademarks and has been registered in many, many countries. In Indonesia, there was a registration for IKEMA in class 21 before IKEA was registered in Indonesia. But IKEA could prove the status of well-known mark, and the commercial court again initially rejected the claim from IKEA, but the Supreme Court decided to cancel the IKEA mark, arguing that it was IKEA was well-known and was registered in many countries. So this is a 2012 case. The Giordano case was a 2006 case. And last, I want to conclude with Hugo Boss versus Zego Boss. And so Zego Boss is registered in several classes. Hugo Boss filed for cancellation. Here again, the commercial court rejected the claims originally. However, the Supreme Court canceled the defendant mark, declaring that Hugo Boss and all the variation of the mark were well known. And in this specific case, also Zego Boss was clearly registered in bad faith. It was very similar with plaintiff well-known mark, and so there was an intention to copy the plaintiff marks. So, you know, what are the conclusion? You know, here I think the conclusion here are that it's clear that well-known marks are frequently copied in several countries. That's not something that happens only in newer countries in terms of developing trademark system a bit after developed country, for example. We have clearly seen in the United States many companies try to copy well-known marks, the same in the European Union. And so well-known marks are frequently copied in several countries because they're well-known. And there is often bad faith that is linked to the copy of these well-known marks. Trademark law internationally does provide a framework to address the protection of well-known marks. This framework is, because of all trademark law is territorial, based on territoriality. However, also recognize the right that is acquired abroad, whether through decision, through use, and even though the mark has to be well known in the country of opposition, certainly the well-knownness is also based on right acquired abroad. So even though its territoriality is also based on recognition of other countries' decisions or other country use. Now, the interpretation of relevant concept, and this is a very important issue for each individual jurisdiction, relevant, public, degree of recognition, reputation, well-known, famous, is still very territorially. And that is crucial for national IP offices to navigate these differences, even though we have overlaps, and we also have guidelines telling us that these concepts are similar. We should be very mindful to this to see which concept apply in what, in which jurisdiction. National IP Office have precedent and guidelines for examination regarding well-known marks. And if they don't, it's really important that they still develop guidelines, because these are very important decision. Of course, have developed relevant precedents. So I would say there is a growing body of law that national IP offices can turn to. I still want to really point to the European IP Office guidelines, because they are well detailed. They include cases decided in favor, cases decided against, cases decided on each specific terminology in each specific part of the various provision. So you can find an excellent guide for all possible concept. And this could become a very interesting model for national IP offices in the region as well. And so with that, I thank you. And I will be delighted to respond to some of your questions.
Thank you very much, Irene. We are going to read a few questions for Irene, and the rest that we will not be able to answer, as we mentioned earlier, will be answered via the IP Key Southeast Asia website. Okay, first question: how do you balance the protection of well-known marks and the need to protect and promote local brands?
So I think it's actually a very good question, but before I answer, I ask a question back. Why are these two incompatible rather than actually being very compatible? We should protect well-known marks in every jurisdiction, because that's what the law tells us to do, and because that's fair competition. And to protect well-known marks doesn't affect in any way the protection of local marks, and actually the development of local industries, because we don't want local industry to be based on copy of foreign well-known marks. That's a recipe for insuccess. I say that very honestly. A local business, even local, wants to be as innovative and original as possible, and so should create their own brands. Also because they might want to have, and I think the example of Gojek in Indonesia, or think about Red Bull in Thailand, are very fantastic stories of international success. If suddenly we have a local business that has copied a well-known mark, even with some variation, and then that business becomes famous and wants to branch outside the country, then can't, or has to rename, because now outside the name is of course protected. So I think this is in the best interest of any country to protect well-known marks, because that's fair in competition, because we want our own businesses, small or big, to develop their own names, because that is, first of all, what's right. You don't want to create a business that just copy, but you particularly names, but you also can jeopardize potential expansion of national businesses into international market if these names are based on copying, because then you will need to rebrand everything. And so I think is actually precisely to protect and promote local businesses that we have to promote a fair competition environment, and fairness in competition is truly based on non-squatting famous trademark. So the Zigo Boss doesn't even have a need to call Zigo Boss. They can invent their own name. As again, Gojek invented their name. So then now they have a beautiful platform that they can expand across the world because they started with an original name from the beginning. And I think that's really, it's the way to see that. I would much rather understand that we say we should not protect patent beyond too much because we need to be able to access technology. But access technology is very different than copying names of famous mark just because it could be a bit more convenient in the short term. It also is very deceiving for the Indonesian public, the Thai public, the Malaysian public, that will just see local products as a copycat of foreign products. So I think precisely for national businesses, it's a bad idea to copy famous foreign marks. And that's, to me, is the number one reason. The number two reason is really because that's what we have to do for international obligation and for fairness in competition in general.
Thank you. So is there a registry of well-known marks that can be used by examiners in their examination work? And as a follow-up question, is it advisable for a national IP office to have a registry of well-known marks?
Okay, that's a very good question. Some countries, very few countries do have a register of well-known mark. Because things change and some of these factors might be changing with time, I don't know to what extent having a register of well-known mark might be advisable and how reliable that registry would actually be. One thing is the ultra famous trademarks. So, but I would think that perhaps is not, that's priority number two. I think first, a good framework would actually be a better idea.
Thank you. So has there been a court decision that sets the parameters of what can be acceptable evidence of well-knownness of a trademark? That also takes into account, I think this refers to all the hype created because of social media. So if the question is whether there has been a court decision dealing with well-knownness of a mark that takes into account social media or like the artificial fame that has resulted from social media.
I would say yes. Now, the court decision, particularly in this region, about how much evidence, I would say, you know, just citing specifically only social media, say influencer, for example, I would say not yet, but the amount of advertisement we have seen in all the various factors, the degree of recognition also based on advertising, and that's even is in trips. You know, in Article 16, that's clearly a factor. And considering the importance of social media, the importance of influencer, that's probably is one of the number one evidence today. Advertisement is no longer done traditionally through billboards. Advertisement is primarily done through social media nowadays. I would say everybody's familiar with the very big success that TikTok has had in you know, in the past few months, and I am quite sure TikTok is not registered everywhere in the world yet, but certainly is become an incredibly famous trademarks, and I would not be surprised if we would see an amount of, again, trademark squatting for TikTok for different type of products in the next few months. And so TikTok being a social media itself, would that be able to rely on the well-known mark status? I would rather say yes. So I think social media is really the new avenue for establishing fames and reputation and well-knownness, number of followers. All these are very strong quantitative and qualitative evidence. So absolutely, that's a really good question. And I would say the answer is yes.
Thank you. So in the USA, what remedy is better for the trademark owner? I suppose this question can be for any other jurisdiction. So is it cancellation of a trademark or unfair competition?
So I think actually, I would reformulate the question. So you can have cancellation, but you actually can have damages. And in the United States, damages can be statutory damages as well. And so that becomes very considerable. I would say that's not the case across many other countries. Some jurisdictions are not as strong in terms of damages. In the United States, damages can be, as you have seen earlier, the use by, the mockbuster company of a mark that was similar to the Frozen actually resulted in $100,000 in damages. And so it's not just the cancellation is the first thing you want, but damages and actually, pecuniary damages, it's a very relevant part as well. And that becomes the deterrent. The first deterrent is cancellation, but if we can just have cancellation, all the costs are, of course, borne by the plaintiff that has to police their marks and has to make sure nobody copies them unfairly or in bad faith. But actually, sanction and damages for bad faith registration become a very important tool, something that I think I'm not a maximalist enforcer, but, bad faith, these are not good businesses. These are businesses that clearly want to tarnish or take advantage unfairly of somebody else's established reputation, creating considerable damages to their sales and potential ability to be recognized in the marketplace. And that certainly create additional effort. So jurisdictions should very carefully consider statutory damages or damages in general, because there is a loss in terms of goodwill that can be also quantified monetarily. And that's something that, of course, at the cancellation for opposition, it's not, that's not the case. But, if we end up in court, particularly for uses of these signs, well, damages could be an important part of the narrative as well, I think.
Okay, thank you. We have time for maybe 2 or 3 more questions. In the case of a mark that has not been used for at least 3 years, that was probably never used for 3 years, can this be used as a ground in a case for bad faith registration?
So it depends on the jurisdiction you are. Some jurisdictions look at abandonment for a period of 5 years. Mostly the United States, for a period of 3 years. I would say again, if there is a clear intent by the trademark owner not to resume use, then I would likely exclude a declaration of bad faith. But if the use has been discontinued for reasons that are unclear, perhaps the company is going through some financial trouble, or there may be other reason, I think it's a bit of a difficult assumption to assume that at the cutoff of 3 years, automatically the bad faith would be excluded. I would take a bit more nuanced approach and err on the side of caution. It's not if now Gucci, for example, has abandoned it or is no longer using certain of their monograms as before because they have innovated a bit, but they have not abandoned it. those. So can somebody else run and using them after 3 years, or even say 5 years, if the cutoff is 5 years? I would be careful about that, because this could still be an unfair competition, even though there is no longer a registration trademark enforcement claim. So I think it really would depend on a case-by-case basis to be safe.
Thank you. So is there a difference between well-known mark, famous mark, and a mark with reputation? So this was in an earlier slide of yours. So must it be international or is it territorial?
Well, this is a great question. It's a $100 million question. It's really hard to say. As I explained, the terminology varies. The international framework uses well-known. The US uses famous. Famous seems to be a bit higher. So it's a bit higher threshold, the general public versus the relevant sector of the public. Mark with a reputation actually is lower than well-known. Back in time in the European Union, we even had a decision that said reputation in one of the member states only, in a part of the member state only, was sufficient. Here again, it would go down to a case by case. Some product, say medical products, the relevant sector of the market is really the doctors who buy the products far more than the patient. And so that qualification of expertise of the doctor might vary the definition of reputation versus a mass product, say as a toothpaste or gym shoes. So I think there is a clear distinction, and then it really depends on what each jurisdiction provides for in their law definition. But the argument can also be made that if the protection is for famous mark only, not for well-known marks, and well-known marks will be found to be protected below the standard of Paris Convention TRIPS. If that country is also a member of this convention, which of course it is because most countries in the world are, then there could be an issue of non-compliance. And so I would say that at least the word famous and well-known are very similar, even though then territorially, if there is no registration, the actual protection might be less. And that again, might create an issue of compatibility with the international provision. But this is a really important question. It depends. So the short answer for practitioner is it depends on what your specific jurisdiction says. What the law is, you have to look at the national law and base your advice to client on the national law. On the other side, for legislator implementing international provision, the advice is implement at least well-known trademarks rather than just famous, because famous is a higher threshold, or implement mark which have a reputation, which is a degree below, but can encompass, of course, also, as again the guidelines of the European IP Office identify, within the well-known is the reputation. So giving larger protection to reputation automatically expand that to the well-known marks as well. But that does remain, one of the crux of the problem is the definition.
Thank you. So can a mark that was previously well-known but is no longer well-known now, can it be automatically canceled?
Well, that's a good question. And the question is not just for the well-known marks, it's for all marks. If a mark is well-known and then it's no longer well-known, but it's still used, then somebody else apply for different goods and services, and I use my no longer well-known marks to cancel that? And the answer is probably no. Because I can no longer rely on the well-knownness of the mark, because the mark, whether the mark is well-known is assessed as of the moment of the complaint. Then you have the other question. Your question can be interpreted in two ways. Is a mark that is no longer used, well known or not, can automatically be canceled from the registry? I wish, I would really like if the offices would do some regular checks of use and then cancel everything that is not there. But the reality is offices don't do that ex officio, just because the lack of ability to do that and the complication of doing that. You have several thousand registration on every year basis. Shall we go back and, in the US, every 5 years, you have to file a continuation of use, but even those tend to be fairly bureaucratic requirements. So the safest bet is a cancellation action is really triggered by somebody applying for a cancellation action. At that point, the office looking into that specific trademark registration and assessing whether the trademark registration is still on use or not. But if a mark is no longer well known today, still used, then it cannot be relied upon to cancel another mark registration or application, or to oppose validly an application in the similar goods and services. That clearly, to me, it's the case.
Okay, thank you. So we have one final question. What is your opinion on parody marks in relation to protection of well-known marks?
Well, this is clearly an exception. I didn't put the exception or limitation in the presentation, but all marks have limitation, and they can be used for news. They can be used in most jurisdictions for comparative advertisement, and they can also be used for parodies. Parodies are the essence of freedom of expression, and in the United States, the courts have consistently said that even if they're used for commercial purposes, they can be used. So the fine line between tarnishment and parody, I tend to be personally in favor of parodies. I think that when you become famous, then you get parodized is almost a sign of success. And the question is, should the trademark owner be able to control? Trademark owner will try to control. Eventually, they can't really control every funny use of their marks that is used on T-shirt or for some, promotional products that are simply a parody. That's very different than somebody else using a similar sign for an actual business. And so I think I don't really have much problem with parodies, just because this is one of the exceptional limitations of trademark law, and it's also not necessarily a problem. Now, the point is to what extent a parody is acceptable when it's not too vulgar. And so if it becomes, again, an adult entertainment or bad, really, really bad words parody, or, racially charged parodies, that's acceptable. And I think then is really where there is a line between freedom of expression and tarnishment, and courts have found that no longer to be a parody. The other issue is parody should be funny. Who is the deciders what's funny? Well, and so that's, again, some really bad taste, messaging disruptive parodies are no longer parodies. And so that remains the issue. But trademark owners sometimes they really have to pick and choose, because they cannot go after every single parody, even though they could have the right to try, they might not be able to. And so here again, it's really, it goes down to a case by case, but generally parodies are allowed.
Thank you very much, Irene, for answering all the questions and for the excellent presentation.